Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we love to take real-life examples and use them as teachable or learning moments, and we're going to try to do that today. But this is a disturbing case. It's not so disturbing about what happened. It's disturbing about what is happening. I'm talking about Daniel Penny and the current prosecution in New York of him for one count of second-degree manslaughter and another count of negligent homicide. It appears that Mr. Penny was acting in defense of himself and many others when this occurred, and it appeared at the time of the incident that he was going to be allowed to go home and no charges would be filed. That's when Alvin Bragg, of course, got involved, and now Mr. Penny finds himself fighting not only for his freedom, but his entire life. So today, let's slow it all down and let's talk about what the Daniel Penny case can tell all of us about self-defense. Okay, hey, before we get going too far down the road we're going down, proud to announce that this video is being brought to us by the Sonoran Desert Institute. That's right, arm yourself with education today. Launch your career in the firearms industry today through education, and most importantly, defend the inalienable rights of millions of Americans nationwide, all through education. Listen, they got a program for just about any desire or need you may have. For more information, visit my good friends at the Sonoran Desert Institute at sdi.edu or check them out in the description box below. Okay, everyone is debating this case. Everyone's all up in arms in this case, and they should be, because I believe that this really is yet another political prosecution coming from District Attorney Alvin Bragg. We're talking about Daniel Penny, a former United States Marine, and Jordan Neely, the deranged individual who walked into a New York subway car high on drugs, acting completely erratic, and then started threatening to kill everybody in the subway car. Many of the individuals who were in that subway car truly believed that they were in imminent threat of death or serious bodily injury. And at that point, Mr. Penny stepped in, subdued Mr. Neely through the use of a chokehold. There is debate as to how long this chokehold lasted, but by the time medics got there, Mr. Neely was still alive with a faint pulse. He was taken to a hospital where, unfortunately, he did pass away. Mr. Neely was not the best of people in the world. He had a very long criminal history and was acting in a horrifically erratic fashion that day on the subway car. Now, nobody presumably knew of Mr. Neely's long criminal history, but they rather assessed him based upon his present day behavior. Now listen, I do not disagree with all the people who are out there yelling, hey, this case should have never been brought to trial. This case should have never been brought to trial. And of course, one of the things that the state of New York is going to try to prove is that maybe Mr. Penny might have had the ability to use force, but he used disproportional force, okay? What I decided to do was take a look at what would a jury be instructed in the state of New York as to self-defense laws. And then I also had a chance to go through the New York penal law, specifically sections 3510 and 3520, which really talk about the use of self-defense in the state of New York. The self-defense statute that would apply to Mr. Penny's matter specifically reads, "The use of physical force upon another person which would otherwise constitute an offense is justifiable and not criminal under any of the following circumstances." And then you go all the way down to subsection 6 and you see this one. "A person may, pursuant to the ensuing provisions of this article, use physical force upon another person in self-defense or defense of a third person or in defense of premises or in order to prevent larceny of or criminal mischief to property or in order to effect an arrest or prevent an escape from custody. Whenever a person is authorized by any such provision to use deadly physical force in any given circumstance, nothing contained in any other provision may be deemed to negate or qualify such authorization." And then, of course, because New York is not super strong on self-defense laws, they do put some quantifications on when you get to use force, but that's found in section 35.15, which reads, "A person may, subject to the provisions of subdivision 2, use physical force upon the person when and to the extent he or she reasonably believes such to be necessary to defend himself, herself, or a third person from what he or she reasonably believes to be the use or imminent use of unlawful physical force by such other person unless Okay, and here's all the times you don't get to use physical force. They are: A, the latter's conduct was provoked by the actor with intent to cause physical injury to another person. Does not apply. B, the actor was the initial aggressor, except that in such case that the use of physical force is nevertheless justifiable if the actor has withdrawn from the encounter and effectively communicated such withdrawal to such other person, but the latter persists in continuing the incident by the use or threatened imminent use of unlawful physical force. That's what we call the first aggressor standard. That is a first aggressor standard definition, literally in a nutshell. That does not apply because we know that Mr. Neely was the first aggressor here. He's the one that barged into the subway car and started threatening everyone. And then the third exception is C, the physical force involved is the product of combat by agreement, not specifically authorized by law. Okay, and certainly this was not an agreed mutual combat. And then the law says that, listen, when it comes to deadly force, there's a couple of other exceptions, including this one. A person may not use deadly physical force upon another person under circumstances specified in subdivision 1 unless A, the actor reasonably believes that such other person is using or about to use deadly physical force. Even in such case, however, the actor may not use deadly physical force if he or she knows that with complete personal safety to oneself and others, he or she may avoid the necessity of doing so by retreating. Except let us remember that they are all on a subway car with this guy. Are we actually expecting them all to retreat off that particular subway car while the subway is underway? So that is what the law actually says. What's a jury going to be instructed? Well, I found the pattern jury instructions, and this is how a jury, including Mr. Penny's jury, is going to be instructed. With respect to the counts charged, the defendant has raised the defense of justification, also known as self-defense. The defendant, however, is not required to prove he was justified. The people are required to prove beyond a reasonable doubt that the defendant was not justified. I will now explain our law's definition of the defense of justification as it applies to this case. Under our law, a person may use physical force upon another individual when and to the extent that he or she reasonably believes it to be necessary to defend himself, herself, or someone else from what he or she reasonably believes to be the use or imminent use of unlawful physical force by such individual. But it gets a little bit more complicated than that because the instructions also state the determination of whether a person reasonably believes physical force to be necessary to defend himself, herself, or someone else from what he or she reasonably believes to be the use or imminent use of physical force by another individual requires the application of a two-part test. The test applies to this case in the following way. Oh boy, we're going to have to meet a two-part test. What are they? First, that the defendant must have actually believed that, in this case, Mr. Neely, was using or was about to use physical force against him, her, or someone else, and that the defendant's own use of physical force was necessary to defend himself, herself, or someone else from it. That seems completely reasonable. What else do they have to prove? Second, a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had the same beliefs. And there is numerous individuals who were on that subway car who believed their life was in danger, that there was an imminent threat of death or serious bodily injury. That was their beliefs, and therefore if Mr. Penny believed the same thing, that would clearly be a reasonable belief. But maybe the case is easier than that. Maybe we don't even have to worry about how long he had him in a chokehold. Because we know under the general rules of self-defense that all self-defense has to be 1, necessary, 2, reasonable, that is objectively and subjectively, and 3, proportional. We also know that you don't get to use lethal force unless you are in imminent threat of death or serious bodily injury. Somebody else in your presence is in imminent threat of death or serious bodily injury. There's a felony being committed upon your person, or there's a felony being committed inside your home. However, if numerous people on the subway car already believed that Mr. Neely was placing all of them in an imminent threat of death or serious bodily injury by his threats to kill everybody and his otherwise erratic behavior, well then Mr. Penny is presented himself both with himself being an imminent threat of death or serious bodily injury as well as everyone else on the subway car. And therefore, he may actually be lawfully justified in going over and not placing him in a chokehold, but killing him instantly. Listen, I would love nothing more than to see the court just dismiss this case at the conclusion of the state's case. I don't believe that's going to happen because I don't have any faith in the New York criminal justice system. Our real hope is that the jury is going to correctly apply the law to the facts as presented and return a just verdict, which is going to be not guilty by reason of self-defense. Listen, we're going to go ahead and link it all up down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. Cool, let's hear about it. Click on that link right there. Let us know. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.